Crocker Acevedo.
Okay. This will also need to move to Judge Hahn's docket. Looks like there's been a disqualification filed. So how much time do you think you need?
It's actually super close to being done, but I believe both of the attorneys are going to need some time with it. So probably 2 weeks.
All right. Are the attorneys present on this one?
Mr. Anagnostou and Mr. Swenson.
I don't see either of them. So we probably need to wait a minute till what we said they show up and we can address that.
Okay.
So
thank you.
Let me go ahead and take one more call. That was
Next
next
for
time.
Sanders.
This is Christopher Ram for Christopher Ram.
Good afternoon. I'm looking for Ms. Sanders. Just a second here. Lena Sanders.
Yeah.
All right, I'm not seeing her. I'm gonna call one more case. I'll come back to this. Sometimes we have some trouble with folks getting signed in, so I'll take another matter, then I'll come back to this next. Ms. Winkles, good afternoon.
Good afternoon. That matter's ready, Your Honor.
All right, is Bunton Min or anyone representing him present?
And we've received no response, Your Honor.
And we didn't receive one either. If you want to send over an extension of the order as requested, I can go ahead and approve that after docket.
All right, thank you, Your Honor.
That matter's ready.
Welcome. Morning. I saw.
Your Honor, I'm in the courtroom.
There we are. Okay, great. Okay, and all right. So, ma'am, did you get a copy of the proposal? You can come up to the table by the microphone here. Yeah. This was. Did you receive a copy of that?
Their proposed order?
Yes.
Yes, I did. And I countered back in an email and then didn't hear anything. I also submitted to the court yesterday, which was very short notice, but I have had a very sick baby. I submitted some additional information, both to his attorney and to yourself, to the court.
Give me just a second. Did you receive that, Ms. Gilmore?
Grayson, good night. I received, sorry, that wasn't me. I received an unsigned declaration yesterday evening. It looks like it's not necessarily objections. It's kind of re-arguing the underlying motion.
So, ma'am, this is on for essentially presentation of the order that was orally issued on the 16th. So the question today really is, does the order that you got, does that reflect what was ordered on the 16th?
From my understanding, nothing was ordered on the 16th other than Ms. Gilmore to recalculate.
Right, based on the $3,000.
Yes, because
income.
she had not calculated my
That's fine.
income correctly. And then basically just to kind of show why I believe he shouldn't be paying such a small amount for child support. I never really got a chance to put a declaration in to express my side of what was going on. And every time we've been on Zoom, I've kind of been cut off and not been able to speak. So I wanted to show up in person today so that I could hopefully get a little bit more of what I'm asking heard.
All right, well, this hearing is about whether or not this piece of paper says what was ordered last hearing. If you want to have that reconsidered, you can certainly file that request and have that considered. There's a process to do that.
Okay, I was under the understanding that it was just, we were just calculating numbers.
Right, she had to recalculate based on the $3,000, which was what I had set that at.
Right, which is why I had told on the 16th, I had mentioned that I had proof that he had been employed and working under the table and that I would provide that proof at our next court hearing, because they're basing, the pay is being based off of his basically indigent, like not working. And so they were using minimum wage, 40-hour work week, which isn't consistent with what he's actually doing.
The court didn't reserve on any sort of argument. The court set the incomes. She did have the opportunity to respond. It was timely filed. And the court ruled based on the information before you.
Yeah, I'm looking at the notes. I don't recall the only thing I didn't have the right calculation because it has to be run through the computer to get to that number, but I had set the two incomes based on the information I had. So that's what this order will say. Again, you can certainly have to have that reconsidered, but the issue today is whether the order says what I said. And it's, when I looked at it prior to court, I did not see your declaration until just now, but when I looked at it, it had the incomes in, and the worksheets appear to be correct.
I don't know, Your Honor. I asked for paperwork showing I was on FMLA from September until December. And then I worked for just a few days before my daughter was diagnosed with pneumonia and had to take time off. So the income, my financial record that I turned in was my income prior to going on FMLA. And so I don't know, I had attempted to ask that, but I didn't get a clear answer as to if that made a difference or not. I'm just not aware of.
Well, if you're back working, it wouldn't, because that would have been a time period that you wouldn't have been employed. But this is based on like a monthly income.
What?
So, just looking back here, just a second. I mean, unless you're, if you don't agree with the order, that's a different issue than if the order says what the ruling was.
Right.
So the order seems to say what I said, and I looked through your declaration, and you certainly can, like I said, you can file a request to have it reconsidered, and they can respond to that, and we can take a look at it. But at this point, the numbers are what I said they were at the last hearing. So, and then let me see here just a second. So it looks correct from what I can tell. Like I said, you certainly can file a request to have it reconsidered and take a look at that information. Okay.
And then, Your Honor.
Yes.
I also was going to ask about filing our taxes. It is now beginning of February, and I am trying to recomp all the costs, medical expenses for out of pocket. The petitioner and our children are on my private insurance, so I have co-pays and deductibles, and our son had a broken arm and needed numerous ortho appointments and physical therapy. And so I would really like to be able to claim the kids this year because I have financially provided for them all 12 months of the year. And I think without the petitioner paying any support in the last 4 to 6 months, it just makes more sense to allow me to claim them.
Okay, well, that's an issue. I said you should talk with Ms. Gilmore. If the two of you can agree on that, fine. If you
I've
can,
attempted, but
well, Ms. Gilmore, have you had a chance to talk about the taxes?
No, I'm not. I'm happy to try to resolve any issues we can resolve outside of court. But the current order reflects reserved. The parties were married for a majority of the year. My clients, we made argument about the client's income. We don't need to argue taxes, but I'm happy to try to resolve it.
Right. Yeah. And like I said, if you can't get it resolved, I'll be happy to take a look at it. Okay. So that I will enter this order. And then, like I said, if you want to have that reconsidered, there's a process to do that. I can't give you legal advice. There's a way to do that. And then if you can't work out the taxes, I'm certainly happy to reconsider that issue and address it. Okay.
Thank you.
All right. So that'll be all in that case today. All right. Ms. Sanders, can you hear us?
Yes, sir.
All right. Great. Thank you. So I did receive a couple of documents on this case. One was a supplemental declaration that was filed, looks like February 1st. Ma'am, did you get a copy of that?
Yes, sir. Oh, okay, so going on my video.
Uh,
Yes, sir. I did get a copy of that. I did not receive a copy of that.
Mr. Ram,
Okay.
I'm asking her whether she got a copy of your paperwork. So I just need to have you hold tight. You have an attorney.
Oh,
You don't have an
sorry.
attorney.
Sorry.
So did you receive a copy of that, Mr. McRae?
I have a copy of our declaration. I don't think Mr. Ram filed anything new, Your Honor. I represent Ms. Sanders.
Right. I didn't see any. Give me just a second, make sure I'm not missing something, but
You're not, Your Honor. If I may, I did not file a declaration. They filed their supplemental declaration on Friday, this last Friday, which gave me obviously no time to respond to it and put it before Your Honor in time for court. And I didn't really see any reason to waste your time with a declaration for me, whereas she's repeating herself. And really the only thing that's in that declaration that means anything is the fact that that they have contacted the insurance company, they mailed out the check, and then she signed it. And that's really the only new information that's in that declaration. So I really didn't see any reason for me to, rush to the courthouse and miss work and get you a declaration by Monday.
Yeah, that's perfectly fine. I just want to make sure I'm looking at everything.
Okay.
So
Yes, sir.
So I do have all that.
Yes.
It looks like the check was sent off.
Yes.
The posture right now, Your Honor, is we're waiting to see if the insurance company will send the check back with their signature on it so we can deposit it. As soon as it's deposited, we can make arrangements for Mr. Ram to get the work started. I understand he needs a 10% down in order for the contractor to start. There's still going to be more billings needed in this. I understand that the damage totaled about $20,000. So there's going to be another check at some point. At least now I think we have the procedure in place for handling that with the loss track and between the mortgage company and the insurance company.
That's what it appeared when I was reviewing through this. I mean, I think we just need to get the thing moving and get it moving through the system so everybody can get repairs done.
Yep, we're on track.
Yeah, well, I agree with that, Your Honor. Can I have Your Honor's time for a minute? My curiosity is it took 9 days, even though it took me 2 times taking her to court to get this check signed. It took 9 days for her to actually take care of it and got it done all in 1 day. As you can see by the check and the receipt for the mailing, this, that, and the other. She got it all done all in 1 day. So I'm just curious as why it is that I have to be living in the conditions that I've lived in when she clearly got it all done within a week or so, when I've been sitting here for a year. I just hope that Your Honor, sees this as a contempt, because clearly this is a lack of responsibility on her behalf, and not just her. It's also on Vernon McRae, because this was ordered by the court for Vernon McRae and for Talia Sanders to handle this over a year ago, and it just simply didn't get done until I had to go to court. And I just don't see that should have happened when it's been before the courts twice now.
Your Honor, there's a process put in place. We were not able to do what the court had originally wanted us to do. Mr. Ram has made, in the last 3 years, he's made a total of 3 inquiries, 3 telephone calls. There was a process that needed to be done. My client was not aware of that process. She had to go about herself to find out what the process was. Mr. Sanders sat on this himself for at least a year the first time when the first check had to be reissued. So this is not a situation where Mr. Ram comes to the court with clean hands in any manner whatsoever. We did as the court has directed. We have the process in place now, and things will move along.
Well, I appreciate that things are finally moving along. My point is to this is absolutely, Vern, you're wrong. She did sign up for the track your. Okay. She did sign up for it. She signed up for it under my name, as a matter of fact, used my name to do it, and it was done weeks ago.
All right. Well,
the thing is,
hold on, sir. Sir, hold on. I reviewed all of your pleadings. I understand your frustration. The important thing at this point is we got it moving forward. We'll hear from the company, and if there's more additional steps need to be done, I'm happy to take a look at it if I need to do anything else. Okay. Well, I just asked you to get it resolved, and I'm aware of the concerns.
Okay. Well, I just asked Your Honor that the legal fees be covered, because at this point with the consulting and to get this all handled and stuff, I mean, like I said, it took 3 times now in court technically to get this handled when I've been living like this for 3 years.
Your Honor, Mr. Ram hasn't incurred any attorney's fees that I'm aware of. He's been representing himself. Ms. Sanders is the one that incurred fees in responding to this.
I want to clarify. I did not say attorney fees. Let's be very clear that these are legal fees, and whether I'm getting representation and I am consulting an attorney are 2 different things. So yes, I do consult somebody and I do incur fees. I'm not at any point saying attorney fees. I do have a consultant, and I have to have a consultant because I'm going up against an attorney. So if I don't have a consultant, I'm a construction worker. Simple.
Right. At this time, I'm not going to impose costs.
Thank you, Your Honor.
Okay, go ahead.
Thank you, Your Honor.
You're welcome.
On my docket, it was listed as number 10, but it might have been moved. The Crocker versus Acevedo.
I do not see that on my docket.
It was at one point.
Oh, yeah, we moved that? Oh, I'm sorry.
It's the one I referenced earlier, Your Honor.
Got it. Okay. Yeah, this is one, Mr. Anagnostou, that will need to be moved to Judge Hahn's docket.
Okay.
And so at this point, it'll just need to be, did we set a new date on that? We did not. So that'll need to be noted for any future hearings in front of Judge Hahn.
All right,
Can
can
we
we,
schedule it now, Your Honor?
I can move it to another docket if you want. When do you want to, if you want to do that? It was just on for review today, as I understand, so that there's no motion pending.
correct, and we've had emails going around between council and the guardian ad litem. She needs a little bit of additional time to complete her report. I can't do next Tuesday, so any other day I'm available after that, or not next Tuesday, but the 20th.
And
You-
I'm going to be out on parental leave starting the 24th, so I was hoping to have this before then.
I could put it on for you on the next Tuesday for the Judge Han, and she can determine, I don't know if that's enough time for the JL to get paperwork done.
I'm this close.
That close. So if I put it on for next Tuesday morning, do you think you can get paperwork
Yeah,
out?
I'm hoping to file it late tomorrow.
Okay. Well, let's put it on for the 13th at 9 o'clock then, and you can review it, determine how you want to proceed forward. Yes.
Thank
Okay.
you.
This is on
Welcome.
for
Thank
the final GAL review of Ms. Day's report.
Okay.
Originally, we were set back in November, and then all the parties agreed. Ms. Poplawski was not available originally for October, so it was agreed to be set over to November. And then when we started the reunification after Judge Bassett's order, she set it out to the 30th of January. And then, of course, you folks had your criminal flow meetings and whatnot that canceled last week's docket. So we were here today for that final GAL report. I know that Ms. Day forwarded to Ms. Poplawski and I yesterday the counseling records from the tribe. I had forwarded to Ms. Poplawski and Ms. Day the counseling records from Ms. Anderson. I know that Ms. Day had communicated to us about needing additional time to complete her report. I don't know how much additional time she needs. But I mean, obviously we don't have the final GAL report yet. There's a lot of moving parts on this one.
And Your Honor, this is Ms. Poplawski, and I think I agree on most of this, except for the fact that my understanding was today was mostly a review of what's been going on with regard to the reunification counseling and not necessarily where it had to have been a final GAL report. I know we have some further recommendations from the reunification counselor that I think the Judge Fassett probably needed to make a decision on. I think that's completely separate from any final GAL report. I do think that Judge Fassett does need to hear this just because you haven't been involved in this, Your Honor. And so this probably does need to get moved out. I would just ask it be moved out in shorter fashion because my client is waiting on moving forward with the extended visits that the reunification counselor had recommended to all of us.
All right. Well, when I looked at the case, I had no idea what it was on for because there's no motion pending that I could see. It looked like it. So that's helpful why it's on. Judge Bassett doesn't have a family law docket going forward. So if we want to have her here, which I'm certainly not opposed to, I could put it on tomorrow at 1 o'clock and see if they can find you a spot that she could hear it.
I think that would be great just so we can get some direction from her. If she does want it to be set over further for a final guardian ad litem report, or if she anticipated more of a review as to the reunification visits. That would help me at least and my client to understand where we're at with this whole process, since we're still the reunification visits started a lot later, I think, than she anticipated. And so I'm not sure if she wanted an interim review or if she was waiting for a final guardian ad litem report, which I don't even think it's right for a final guardian ad litem report, but I'll leave that up to Judge Fassett.
So tomorrow would just be to find a time because it wouldn't be a hearing. It's just an assignment docket.
Well, and I guess I would object to reassigning it to Judge Fassett. There's nothing unique about this case. We're going to be on the family law docket moving forward. She hasn't been pre-assigned. There hasn't been a motion to pre-assign her. Obviously, my client would be entitled to respond to all of that information. And while I understand that Odyssey doesn't show the background of communications, Ms. Day, Ms. Poplawski, and I have all been included in those communication setting over the final GAL review hearing, which was for today. And obviously, even Ms. Day reached out to us and indicated that she needed additional time. So I think if anything, we need to schedule a new final GAL review hearing. Judge Fassett did not schedule a reunification review. that would need to be noted by way of motion, I believe, unless Ms. Day has some additional input for us.
And Your Honor, Judge Fass has been intricately involved in this and had put in place what should happen relative to the reunification, wanted to know what was going on with that and to have more information relative to that. I think having someone try and reinvent all of this with very delicate matters that have been going on regarding allegations of abuse by my client, multiple counselors involved, to say that Judge Fassett doesn't need to continue to be involved in this, I think that really does a disservice to everyone involved, particularly the minor child, as well as both parties here, Your Honor. So I just completely disagree. And my understanding is that this was supposed to be relative to a review of the visitation and the reunification. There were a lot of pending issues, even certain evaluations that the guardian ad litem wanted, and those were all going to be held over to find out what has been going on with regard to the reunification hearing. And so that really is what has been happening. So I think that Judge Fassett should make that determination whether or not this is something that should remain with her or not, given the extensive involvement and the complex issues that have been happening in this case.
Let me stop you for a minute here, because again, I know very little about the case other than obviously there's a lot going on. Why don't we do this? I don't know. I signed an order in this case, but it was on her behalf because it was a stipulated order from a hearing that she did. My thought is if I stick this on for her on her presentation docket this Friday, you guys can talk to her, see if she thinks she needs to continue on. If she does, then she can make that decision. If she doesn't, I'll come back on this docket at a date far enough out that Ms. Day can get a report done.
So I guess I'm going to bring us back around though to the fact that we need a final GAL review hearing. So
I could just set, I'm happy to set that for you.
Or
I think we can go back on her.
Well, let me stop you.
Just wanting instruction.
Ms. Day, are you there?
I'm here, Your Honor.
Good afternoon. How are you? How much time do you think you need to get a report on this one?
So I'm very close to being done. We did just get the information, the records from the tribe and the child's counseling, as well as through the reunification and the updated letter. So I would need a couple of weeks at the most to finish up and circulate that. And then a couple of weeks, I'm sure, for the attorneys to review and respond.
So why don't we do this? Why don't we do this? Why don't I put a review hearing on this case, on that issue on the 5th? That's 4 weeks out from today. I'll stick it on Judge Fass's docket on Friday, this Friday, the 9th at 8:45. It's a Zoom hearing, and you can discuss with her whether she thinks this is a case she needs to continue for this issue or ongoing. And then we'll go from there. And then if she wants to set a different review date based on that decision, then she's free to do that.
And that makes sense, Your Honor. Thank you.
That work, Ms. McLean?
Yeah, I'll move appointments around. So, yeah.
It shouldn't be a lengthy hearing, I would think. It's 8:45 in the morning, so
I understand.
You go into work too early. So, okay. So,
Ms. McLean works 24 hours a day.
I don't.
The court's aware that's not quite exactly right, but it's close. Unless I hear otherwise, I'll assume this will be back on the 5th, and I'll have a lot more information to work with. So,
thank you, Your Honor.
Thank you, Your Honor.
All right. Thank you. Have a good afternoon. So it looks like was a withdrawal that I think was effective today.
Yes, Your Honor. I spoke with David Gross yesterday, and his withdrawal was effective today. Yesterday was his last day.
Okay. So, and you noted on a motion for default, which based on the fact I don't have a response, I can grant that with striking out the other orders section number 10 of that.
Your Honor, we do have a motion for default set on the 20th of this month. And we did have to set that just due to the lack of cooperation that's been going on in this case. And I do see that there is someone named Ryan here, and I'm not sure if that's opposing party in this case.
Ryan Fowler?
I see a Ryan, just first name in the Zoom boxes. I didn't know if that was opposing party here.
Is a Ryan Fowler present? I didn't see that. It looks like that. So it's not on for, that's a different.
The default hearing is on for February 20th. Today's
Okay.
hearing is for a motion for temporary family law order as well as a motion to compel.
I was reading that file incorrectly. My mistake on that. And is there a Ryan James Fowler present? Anyone on Zoom?
Can you hear me now?
I can. Is this Ryan Fowler?
Yes, sir, it is, Your Honor.
All right, Mr. Fowler, did you receive there was a motion noted to compel answers to interrogatories. Did you receive that?
I did. I sent them to my lawyer. I'm currently in between lawyers, and so things are a little hectic right now. There were answers that were sent, I believe. At least I have copies of them. I don't know if opposing party received those answers or not.
Counsel?
I have not. I have been in contact with both of Mr. Fowler's prior counsel. We held a 26I on November 28th, gave a 2-week extension until December 11th. Still had not heard anything. And yesterday, when Mr. Gross just wanted to know about today's hearing, as he is no longer counsel, the issue of discovery was brought up, and he still has not received anything. Or at least it was not complete enough for it to get to my desk.
He meaning Mr. Gross?
Mr. Gross did not send anything. Josh Baldwin was prior counsel before that, and I have not received anything from Ryan Fowler directly either.
Okay.
Okay, I will make sure that I get a copy of that to you since I have it. I was under the impression it was complete, so I do apologize.
And how soon would you have that to her office, sir?
I will look through what I have today and get it to her by, will end of week work?
It would if there was a guarantee that I would get it, but this discovery has been outstanding since September. This case has dragged on. We have not heard anything from Mr. Fowler since the onset of this case. The only thing that was done was an agreed temporary family law order was put in place on July 10th. So I am not inclined to give him the benefit of the doubt due to the uncooperative nature I've encountered so far with him.
Well, what I think I'll do on this one, and it's in part because of the attorney situation, and I don't know all the background of the case there. I'm gonna put that motion on for next Tuesday, the 13th. If they haven't been received by this Friday, then I'll be looking at fees and possible other sanctions. Well, you need to get those to her office today or this week, no later than Friday close of business. I would suggest sooner than that. I'll review it on the 13th, and that'd be on this docket at 1 o'clock. And if she tells me she hadn't gotten them, then you're going to have some costs. You may have costs anyway. I'm not making that decision today. I'm going to see where we're at.
Fair enough.
All right. And you said there was a motion for.
Yes, Your Honor, there's a motion for temporary family law order in this case. We currently do have a very bare bones temporary family law order that was put in place back in July 10th of 2023. We have tried to work with opposing counsel and opposing party to get some type of parenting plan put in place. As you can see from the declarations, Mr. Fowler's behavior has been very problematic and troubling. He's been in and out of treatment, in and out of rehab. The only way my client is able to track his whereabouts is through their joint checking account to see when he's taking money out and roughly the location of where that is. And he's been in and out of casinos. And there has been an issue as to when he is in contact with the children. The contact that he has had has been extremely troubling. My client has had to shorten phone calls or completely turn off the phone because he will call the children drunk. The last time he contacted them was on New Year's Eve, and their daughter noted that he was drunk, and my client had to cut the call short. There's no reason that we shouldn't have some type of parenting and plan in place thus far. The reason that the motion for temporary family law order was put in, or sorry, the temporary family law order was put in place back in July was so that they could get the house sold. Now that the house has been sold, my client has been living in an apartment with the children, and Mr. Fowler has been doing whatever Mr. Fowler has been doing. So we would ask specifically that the court look at the parenting plan that has been proposed. And while I understand that Mr. Fowler will probably ask for a continuance on this so that he can file some type of response or give some type of input, that time has passed. He's had plenty of time to look at everything that we've proposed. We've talked to opposing counsel to try to get some input, and the restrictions that we are suggesting to the court are more than warranted.
Well, you have a temporary parenting plan within the prior temporary order, correct?
We do not. We just have a temporary law. We were not able to come to any kind of agreement on a parenting plan past order.
No, but I mean, you've addressed the time that under paragraph 4 of that order.
If I may, I was speaking.
Well, hold on a second. Hold on, sir. Just hold on a minute.
Okay.
I'm looking at the order from July 10th.
Are we looking at the order from July?
Yeah, July 10th. Paragraph 4 has, you know, some real strict limitations on contact.
So we did not call that an actual parenting plan. That was just an option to put in place to get something moving on the home sale, to get petitioner and respondent out of the home and to get that sold. But we did not consider that a parenting plan when we put it together, despite the restrictions that are on Mr. Fowler.
Okay. Just a second here. Has there been a guardian ad litem appointed in this case?
There has not been one.
Well, I'm probably going to be looking at that if we're going to be trying to do something more specific than what's in the July order. Just looking at that just a minute here. So if you want to appoint a guardian ad litem, we could do that.
I wouldn't be opposed to appointing a guardian ad litem, Your Honor. My concern is that this case is just going to keep dragging out even further. My client just wants to be done, and due to Mr. Fowler's lack of cooperation with both his counsels and with my office, we would be just inclined to move forward with this case and just go to the default and see where we go there. And then if default is not granted, then I would say that we could revisit the issue of a guardian ad litem.
Okay, I can do that. So if your only request is in the motion, I'm just looking at the difference here. You're asking for, is it the parenting plan, the only request in there?
There's one other request, which is under 14 under other temporary orders. Due to Mr. Fowler's instability, we are not sure if he still has a job, if he is, we've heard rumors that he is going to be laid off sometime this month, but we're not sure. Currently, the temporary family law order encompasses both spousal support and child support with a total amount of $3,000. My client is very concerned that due to Mr. Fowler's instability, he's not going to be able to make those monthly payments, which is going to negatively affect her and the children. So in the other temporary orders, we're asking that my client be able to withdraw $50,000 from the house proceeds that are held in trust at my firm. And the reason that we are asking that amount is that would take care of 1 year of spousal and child support at $36,000. It would also allow room for uninsured medical, school costs, or any other things that pop up within a year if we can't get this case settled. And that would go, that would be deducted from the future assets.
I didn't catch that broke up, that last sentence you just said. I'm sorry.
That money would be deducted from the final division of the community assets, so it would not be just a $50,000 lump sum in her lap at the expense of Mr. Fowler.
So I guess answer this question: has he been making this spousal support payment?
To an extent, yes, but he has not been making it. My client has had to withdraw the money every single month from the joint bank account. We allowed him to try to make the payments when we first got the case going and back in July, and he was late several months in a row.
If I may, the stipulation was I had until the 5th of the month to make those payments, and she would draw the money out before that time.
Your Honor, I would object to what he is saying is I have not seen this in any type of response or declaration.
Well, I'm just looking at your order. It says it's due on the 5th. So, I mean, that is what it says. Well, it seems to me that I'm not going to order $50,000 out of an account. Prospectively, I mean, if the payments money is there, if the money's not there, I would authorize her to withdraw the monthly amount from that trust money. That would make sense. But
would the court be willing to put that into a temporary order?
Yeah, I'm fine with that. If you want to send an order to that effect.
In Your Honor, I am being laid off this month, so I will be unemployed. I'm working on finding another job. So I think that is quite appropriate for her to be able to do that until I get my my affairs settled.
Yeah. I mean, if the money's not in a joint account, then she can withdraw it out of the trust account. Happy to sign that order. And then you've scheduled the default is for the 20th, so 2 weeks.
That is correct, Your Honor.
Okay. So, Mr. Fowler, I don't know, did you receive the notice of the motion docket notice for the 20th?
I do not believe so.
Did that go to
everything was sent? My partner, everything was sent through David Gross's office prior to Mr. Gross withdrawing. In fact, it was likely
I did not catch that last part. I'm sorry, you're breaking up real bad.
I'm going to put myself on just stop my video just in case.
Okay.
We sent over to Mr. Gross's office everything we filed for the motion for default. So I'm assuming Mr. Gross would have given it to Mr. Fowler. And the day after we filed and served them with the default, with the motion for default, that was the day that Mr. Gross put in his notice withdrawal.
I see that. Well, I think just in the interest of, I'm not sure what's going on with Mr. Gross. It looks like within his withdrawal, he gave you an email address. So I'm going to order that. I mean, your time is fine on the notice for default for the 20th, but I'm going to require that those documents be emailed to Mr. Fowler directly, since he's not without counsel and it wasn't sent directly to him. And I understand why you didn't, because he's still an attorney, but given the circumstances, so you should have his email. It's in that withdrawal. You see that there?
Yes, Your Honor.
Okay. So, Mr. Fowler, you're going to get an email with a number of documents in it. You'll need to deal with those. We'll be back on the 20th, and I'll be moving forward with whatever the result of that hearing is at that time. Do you want to put the order from today on for the 20th for presentation to save additional hearings?
Yes, Your Honor. Also, if you could have Mr. Fowler verify his email address, just so we're sure that it's the correct one.
At Gmail.
So, okay, did you get that, counsel?
Yes, Your Honor, I did.
All right. And Mr. Fowler, I'm going to suggest you contact our clerk's office. If you're without counsel, you need to make sure we have your most current contact information. Right. There's either need to come in person or there's a form you can get from the clerk's office to do that.
Fair enough. Thank you.
Your Honor, just to clarify, the motion to compel is going to be heard. We're going to set that over until the 13th, so that 1 p.m. docket. And then the issue of the parenting plan, as well as a presentation of the temporary family law order, is going to be put on the 20th.
Well, you wanted the order about the withdrawal of the funds.
Correct. And
I was putting that on for the.
Correct. And that would be a presentation of orders on the 20th. And correct. I just want to be clear that if on the 20th, the motion for default is denied, at that time, we would address the parenting plan with the motion with the GAL.
We can talk about that on the 20th, correct?
Okay. Thank you, Your Honor.
Okay.
All right. Thank you, Your Honor.
So you need to make sure you get your documents to her this week. We'll be reviewing that on the 13th. And counsel, if you receive those documents timely, my suggestion would be just if you want to strike the hearing on the 13th, there's no reason for everybody to show up if you receive the discovery, and then just appear on the 20th for the other matters.
Noted, Your Honor. Thank you.
Tiffany Jensen here for Heather Fontes, Your Honor.
Good afternoon.
William Ball, Your Honor, for Mr. Stemmerman.
Good afternoon. So I received proposed orders and I received objections to those. So I don't know where you folks are at on that issue.
So, Your Honor, I think what we can do is go through each one. I think the temporary family law order is agreed. So the court can sign that one.
I don't know that I have that. I have,
okay.
It's in the court file, but I don't have an actual order to sign on that.
Okay. The child support order, Mr. Ball just sent me a revised version today, incorporating my changes. So I no longer have any objections to that. We are sending it around for signature. So we'll need to present that to the court off docket, I suppose. The parenting plan, I also understand Mr. Ball has accepted my changes to that. I haven't seen a revised version yet, but I anticipate that that is coming. And so we shouldn't have any more objections to that order. The last one is the GAL order. I'm asking the court to adopt my proposed GAL order. The court we had discussed that I would be preparing that order. I did. Mr. Ball, as I understand it, and of course I'll let him clarify if I'm misstating. It's my understanding he is in agreement with my proposed order, with the exception that he wants to add in the GAL duties, which I believe, Your Honor, are found on page 3 of that proposed order. He wants to include investigation into DV for my client, respondent Ms. Fontes. The only thing that exists as it relates to DV and my client are Mr. Stemmerman's allegations. My client denies any issues with DV. It's Mr. Stemmerman that has the protective order. In addition, Your Honor, we submitted that proposed order prior to the clients submitting to their drug tests as ordered by the court. And those have both been filed under seal. And as the court will see, my client does not have substance abuse issues. Both of her tests were negative, both the hair follicle and the other. So I would be asking if the court is willing to remove my client from investigation as it relates to substance abuse. We included that based on the court's last order, but I don't think it's necessary at this point in time, given her test results. So I think the issues, again, just to kind of narrow it down on the GAL order, are Mr. Ball would like to add that my client be investigated for DV. I object to that because I don't think there's a basis for it. And then I would like to remove any investigation into my client relating to substance abuse, given her clean hair and 5-panel drug test.
Mr. Ball?
Your Honor, do you have the respondent's proposed GAL order in front of you?
Was it in your packet?
It was submitted by Ms. Jensen's office. So I have the one that she prepared. Okay, so
I'm looking at.
And then so there's another issue that we need to address. So you have that in front of you?
Yes, I'm looking at the order.
Okay. Okay, so under section 5, I'm okay with that, except for I'd ask that the GAL investigate allegations of domestic violence of petitioner and respondent. If there's a domestic violence issue in this case involving the respondent, I think the court should know about it. And, that's important for making a parenting plan as well. And then the other issue after that is, I have a response. The court already ordered that the GAL was going to look at the substance abuse of petitioner respondent. We do have some questions about the UAs and the drug tests that were submitted by a respondent, which we're going to have the GAL look at. But the other thing is that the review dates we need to look at again. So we just need a ruling on those things, then we can move on to the next order, hopefully.
All right. Well, I'm not inclined to pull out. I'm not going to limit the GAL's investigation. She's going to take a look at the case, and she determines that there's an issue based on whatever she hears as part of her investigation. She's able to do that. I'm not going to make any changes to this order. I'm going to leave it as is. If she determines that she needs to look into other allegations of DV, which are not specific in the order, or decides that the drug tests satisfy her, then that's fine.
Okay. And we had just Ms. Jensen and I had discussed the hearing dates for the GAL, and I had suggested another date to be added for the final GAL report to be due. And Ms. Jensen, when did you want the dates to be changed to? Did you have?
Well, the order we submitted has the dates of March 6th for the 30-day review.
Mm-hmm.
And then it also has, I believe it's, let me look here, April 9th, I believe was the, April 9th is the interim GAL review. And then June 4th is the deadline for the final report. And those are all included in the current order.
Okay.
I see. There's only 2 hearings set, but there's a final deadline for filing. Typically, we've been setting those for review on that as well. Is that? So what I think I'll do is I'm just going to include that June 4th. I'm going to just put an arrow down that would be an additional hearing.
And Your Honor, this kind of dovetails into my other question, is that the court had asked the parties to submit to a drug test, and we submitted those to the court. And I thought that I'm asking if the court is going to review like the parenting plan again that was ordered based on the results of the drug test. I thought that's what the court had said. Or do you want to wait until the April 9th?
No, what I had indicated was I wanted to take a look at, there was a request to use a drug test that had been previously done. I believe it was the one your client had done. And I wanted to look at that and see if that was satisfactory for purposes of this order. That was the reason I set the review on that. It wasn't anything specific otherwise. The concern I guess I have on this one is this is purely a test for alcohol. So it doesn't test for anything else?
Yeah, he didn't. I don't think I thought I hadn't seen it before, but I thought it was going to be an 11 panel or 7 panel test, but it was just an ETG for alcohol. I mean, I don't think there's any allegations that he's taken any other substances. The main allegation was his alcohol use.
An alcohol test is not particularly useful in most cases because it gets out of the system so quickly. But so I would want at least a 5 panel done. I mean, this has a hair for ETG, and I'm just looking at see what that said. The hair follicle doesn't tell me anything within the last couple of weeks. This does say there was a urine test done, so, but I don't.
Let me see.
But it was purely for alcohol. So as I guess from my point of view, that wouldn't be a sufficient drug test for purposes of this case. I'd want to see at least a 5 panel.
Okay.
And I think she did a 5 and then did a 10 panel saliva test. So.
Yes, Your Honor, she did, and both were negative.
Mm-hmm.
Well, I thought the court had asked the parties to do a UA and not a saliva test.
Well, they did. She did both.
She did a hair test and a saliva test.
Correct.
But not a UA. Anyway.
Saliva and UA give essentially the same results between those two.
Okay.
I'm not fine if he wants to do a saliva test, but I would want more than the ETG.
Okay, we'll do that. And then we'll submit that to the GAL and to the court. And then and so the next order was the temporary family law order that is ready to go.
Mr. Ball, I apologize for interrupting. Is the court going to require a hair follicle that's more than just an ETG as well, Your Honor?
That would be good.
Yeah, I mean, that's what the court ordered, was a hair follicle, a 5 panel hair follicle and saliva, so the court could see historical use and current use. And it doesn't appear that Mr. Semmerman did either. He just did alcohol for both.
In just a second here.
Did a hair follicle test. That's the ETG test. and then they did a UA on the day that we had court. And the UA was just, I don't know if it was for anything other than alcohol.
Yeah, it appears from my review of both the court's notes and the results that Mr. Semmerman provided, he only provided documentation relating to alcohol. So his hair follicle was solely alcohol, and his urine test the day of or after court was just alcohol, and the court ordered a 5-panel for both.
Oh, the ETG screen.
Yeah, I don't know that I ordered specifically 5-panel, but I did order a UA test to be UA follicle. And I'm fine with a saliva test, frankly, but just a minute here. Just going back through. Yeah, drug screen and hair follicle test. So, but an alcohol one doesn't really cover it. So he would need to do both of those.
Okay. Yeah, I don't know if it was specific enough. Maybe my client didn't understand to do a 5-panel test, but we'll do that. Is there anything else on the GAL order?
Not for me, thank you.
Yeah, and I indicated that other hearing of, so we'd have 3 hearings set off the order.
Okay.
The last one being June 4th is a Tuesday. Double check here. It is. Okay, so I've signed the GAL order.
Okay, good. And then I think the temporary family law order is agreed. There was no objections on that, as I understand it.
Correct.
Okay. And then the child support order, we're working on that. The only thing my client wanted the court to know is that he has been paying the respondent's health care and wanted that to be taken into consideration of the arrearages on child support that were ordered, which is.
I guess I'm going to object, Your Honor, to that being considered at this point in time. That was not part of the discussion that we had at the hearing. That's new information. He was ordered to do that pursuant to the protective order. And, for his additional information for the court, given that Mr. Ball has brought this up, he emailed me about that today relating to my client's health insurance. I've confirmed with her that she has her own, and Mr. Stemmerman can remove her from the health insurance by agreement, even though he was ordered in the protective order to keep her on it. So I don't think there should be any credit for that at this point in time. It wasn't argued at the time of the hearing, and it's certainly not appropriate to discuss it now when we're in entry stage.
I'm just looking back through the notes. I don't think we had, there was no objection to the income figures. And adopted the child support worksheet effective 8/1 of 23. Authorized mother to claim the child for 2023. And then reserved on 24 going forward. And if there's an issue as far as filing taxes this year and claiming for the child, that can be brought back before the court if we can't agree on that, obviously. But I think that is what, so I'm not going to make any other changes to that order.
Okay. And then I guess I had some questions on, and this might be, I don't mean to catch Ms. Jensen off guard, but on the parenting plan, are we going to talk about the parenting plan now? Order.
I thought that we had, but
okay. So there are 191 factors in the parenting plan. There was and the one that we've submitted is domestic violence for the petitioner, and then I'm just unclear whether or not the court made a 191 factor as to substance abuse as to either both party or just one party.
Let me see. I don't know that I made a specific finding about 191 factors.
Your Honor, you didn't make any specific findings about 191 factors relating to my client at all. The 191 factors were included for Mr. Semmerman because there is a finding of domestic violence pursuant to the protective order that's been in place in this case for approximately a year, or going on a year in June. There were no findings. There were just allegations by Mr. Semmerman, and to include them in the parenting plan at this point in time is inappropriate and certainly was not ordered by the court, which is why we objected to that being included at all. They shouldn't be reserved. It should be NA as it relates to my client.
So can we take out the substance abuse? Excuse me, Your Honor. Can we take out the substance abuse for both parties then? And just not that, the GAL is going to look at it anyway. So
give me just a second. Let me get to that. At this juncture, I didn't order any 191 findings. The one under A is fine because of the existence of the protection order. The others should be reserved until we have some more information on them under B. because I didn't make any findings on those.
Okay. All right. Thank you.
So everything should be reserved under B.
Okay. Thank you. Sorry for springing that on you, Ms. Jensen. And then, and I think that I think we're okay with the rest of it. We had some problems with the telephone calls, but I think that's going to be a non-issue. There are telephone calls ordered, but there doesn't seem to be an exception in the protection order to allow the parties to communicate through telephone calls. So we might, but we're going to work on that and see if we can come to a resolution. We just haven't. We think the parties can figure that one out without the court.
I think if I recall, and I don't have that in front of me, but I believe that we had deferred in the parenting plan to visitation to be dealt with here, I think.
The protective order outlines parenting time for Mr. Stemmerman, 10 to 4 on Saturdays, and then subject to the family law proceeding. It also includes unlimited phone calls and Zoom calls. And this court, Your Honor, ordered that the terms of the protective order would stay in place until the drug tests were done, the DV evaluation was done, we were getting a GAL involved, etc. I agree with Mr. Ball that there, as I've reviewed the protective order, there doesn't seem to be a specific exception for the phone calls. However, the parties haven't had any problems with that. There haven't been, attempts to get somebody in trouble as it relates to the protective order during the exchanges or visits or things of that nature. I don't think that that's going to be a problem going forward. I think Mr. Ball and I can work out some specific times for those phone calls to start happening on a regular basis. They have not been happening, and whether that's because Mr. Stemmerman was concerned about violating the order or for whatever other reason, I'm not sure. But I anticipate Mr. Ball and I can work with our clients to get something going on that front while these other processes go forward. The GAL, the drug test, etc.
So I'm looking at paragraph 14 in the parenting plan. It talks about that facilitating the calls is not a violation of the protection order. Counsel, if there's a concern about that, if you want to submit an agreed short modification order for the protection order case that specifies the phone calls that comply with this order are not a violation of that, or just for clarification. That's one of the problems with having these two different orders, because if the verbiage is not identical, that can cause problems. But the intent is that that would not be a violation of the protection order.
And my client understands that too, Your Honor. So I think that's why Mr. Ball and I think we can probably get that worked out. But if there is concern, we certainly will take the court's advice and do that.
Yeah, just to be clear on it. So
yeah. So with that, I think, and Mr. Ball, if you have other things, I didn't mean to interrupt you, but there are some things in that proposed parenting plan that Mr. Ball submitted to the court that we have agreed are going to be removed.
Right.
Okay.
Right, and those are in compliance with your objections, I assume.
Correct. Yes.
Okay. So I assume you can work out the language on that. If you can do that, just submit those ex parte to my attention. If not, put it back on the docket. I'd be happy to look at it.
Great. Thank you very much.
All right. Thank you, Your Honor.
Welcome.
Thank you, Ms. Jensen.
Thank you, Mr. Ball. Bye.
Your Honor, this is Nicole Dalton. Sorry, it took me a moment.
Okay, very good. All right, so this is a challenge. I'm not sure that we have enough time today to hear this case. This probably is going to need about a half day or a full day hearing.
Your Honor, may I?
Sure.
Really, the preliminary issue in this case is jurisdiction. I know there are other motions pending. I have to tell the court that I am only willing to handle the jurisdiction and the response to the sexual assault allegation. I am very deep into pro bono. My client can't afford my services, and I cannot continue, in fact, doing anything beyond the UCCJEA hearing, and the response to sexual assault allegation would put me into a position of having a personal conflict of interest that's not resolvable. So perhaps I can ask that we find a way to just deal with the UCCJEA. If petitioner's counsel persists with her CR11 sanctions, I have just now filed a response, which I haven't had time to file because of all of the burden that this case has caused. I would just ask for leave to deal with that later if the court is going to consider it. But if we could first deal with the UCCJEA, I don't know then whether the response to sexual assault allegation needs to even be heard if there is no jurisdiction in Washington because of forum nonconvenience or other reasons. Then we would presumptively potentially transfer everything to Texas. And I would just ask that we focus on the UCCJEA issue first. And I will be withdrawing. I just want to put everyone on notice.
Ms. Winkles?
Yes, Your Honor. A couple of things. It's my understanding that the UCC JEA is going to happen on the 12th. Is that correct?
Well, I reached out or had my staff reach out to a Texas judge to get that on our calendar. I think it is for the 12th without looking any more deeply. And I had a brief conversation with the judge just because he was trying to understand what was going on, because there was one document filed down there or something, a very limited case file, and he wanted to understand what he needed to from their side of things. So at this juncture, I've reviewed through all of the documents that have been filed to the best I could within the time that I've had. Some of the stuff came in fairly late, but I did have a chance to go through a lot of it. And I guess my question is that, I can hear argument on it, but I probably won't be able to give you an answer today because I'm going to have to go back through and try and sort out. I mean, you got two folks that are saying diametrically opposed statements of fact. And I'm not sure I'm going to be able to resolve that without some sort of an evidentiary hearing. And whether that's done in conjunction with the Texas judge, which that would be a challenge because it would be a longer hearing than we would normally set for a UCC JEA type hearing.
If I may let the court know, as far as the Texas issue, my client is having trouble obtaining counsel in Texas because this matter is still pending here. And counsel in Texas believes that as long as Washington is handling the proceedings, she's found several lawyers that have said they're ready to jump in as soon as the jurisdictional issue is dealt with in Washington. My understanding of the jurisdictional issue, there are kind of two prongs here. On one hand, counsel for the petitioner and the respondent have briefed the matter. This court has the ability to make a determination as to whether this court believes it has jurisdiction based on the arguments provided. But I also believe this court can make a decision as to the question of forum nonconvenience or inconvenient forum. That's one thing that we've brought. The Texas matter has also been complicated by the fact that Mr. Diaz has not provided a good address. My client has found a professional process server to attempt to serve him at the address that his counsel provided to me, but that process server indicated that it appeared the residence was empty and that it was not occupied by anyone. It looks like it was maybe an Airbnb or something like that. We can't she can't move forward in Texas without getting service on Mr. Diaz. Mr. Diaz is present today by Zoom, but we have no idea where to find him. And it makes it difficult. So I guess my request would be if we have to have an evidentiary hearing, perhaps we can set that on as far as the UCC JEA to let this court make a decision about the basis for jurisdiction and the forum, the inconvenient forum question. However, it is my understanding that this court would normally also confer with the court in Texas. My client can provide all the pleadings to the court in Texas that we've filed in Washington. Perhaps that will enlighten them. But she is without counsel currently in Texas. And perhaps the two courts need to confer. I don't know if the court would like to, if this court would like to confer with the Texas court prior to considering the UCC JEA questions. That's certainly an issue that's certainly at the discretion of this court. So,
and Your Honor, if I might, the fact is that we don't have service of the Texas orders, which means that there is no commencement of litigation in Texas nor in the state of Washington. The only commenced proceedings, which means filed and served, would be Washington's petition, and it also came first. Additionally, the convenient forum question only comes in when there is no home state. You can see that in my memorandum. So what the court looks at first, it's a priority, it's a hierarchy. The court looks at where the child was 6 months before the proceeding was filed. Clearly, the child, King, was in the state of Washington with his mother. That is not even a question. We have the school records to show that. We then have the question of Dylan. The court goes on to say that if there is one child in a different location than the natural parent, you normally look at the natural parent and where they're at. The other thing is you'll see that Dylan was here and did attend school here for over a year beforehand. She has been, prior to the commencement of this, she had not been in the state of Texas. And you can clearly see her school records show that she left school because she was using drugs in Texas and that she was put into school here. In the state of Washington, it was a dab pen. You can clearly see those school records that talk about that dab pen in the bathroom. She gets kicked out. You can clearly see her, Mr. Brewer, who then essentially applies for her to be homeschooled in the state of Washington. Those records are there for the court. These are a third party that we had no change, no interest in whatsoever. They're clearly there. This forum question is an attempt, once again, to hop the state and to move, contrary to a court order. And this is the real problem that I have today, and the real problem
I'm
that
going to object to counsel making an argument at this point. I think we're just addressing procedural issues.
Right.
The issue is there is an order in place that is a restraining order for mom to present the children to the sheriffs here. It's still a good order. It's not been followed. And this is my issue with putting all of these matters over, is that order is current. There's only one commenced proceeding, that's in the state of Washington. This court has the ability today to make orders because there is only one state that has active litigation. If we put this off and put this off, nothing will have changed except that possibly they will have served the pleadings, and then we will be in a different situation, which will prejudice my client, because clearly, as of today, there has been no service. There has been an attempt to file many months later.
Hold on, you're getting into the argument way ahead in front of the horse here. We're trying to figure out how we're going to proceed at this juncture.
If I may briefly, Your Honor, my client doesn't have the funds or the ability to return to Washington. She no longer lives here. So procedurally, I would say that Mr. Diaz has been evading service. And if we need to affect service by publication, my client would need to do that through Texas, and that may be the next step.
Okay, so here's, anybody have a problem if I speak for a minute without interrupting me?
No, Your Honor.
No, Your Honor.
So when I read through what I could, and I will differ with counsel, I don't think there's anything about this case that's clear. The only thing about the case that's clear to me is there was a case filed here with a number of allegations, which, if true, would substantiate jurisdiction here, at least as it regards to the one child. And I guess the one argument that does seem to complicate this is that there is a response that submits to jurisdiction, essentially, in this case. And that I guess raises a significant burden. I don't know what Texas considers as commenced. In Washington, you commence a case by first filing a summons. That's how the court obtains jurisdiction. And then you get jurisdiction over the person by service. So I don't know what Texas considers commencement. I don't know if they have a commenced case or not. They don't have a served case, obviously, so they don't have any jurisdiction over Mr. Diaz. But at this juncture, my real concern is that you got a case filed here. There is a protection order that was at least attempted to be filed where there was allegations of somebody residing here. This case was filed. The response is filed indicating jurisdiction was correct here. I understand that was amended in a document, or at least attempted to be amended by a document that is post the timelines and was not approved for filing. It would need to be approved before that could even be considered. None of that really overpowers the fact that if the child, in fact, wasn't here for 6 months, then Washington would not be the home state under pretty much any circumstance. But even if Washington is not, and potentially Texas is, Texas very well may decline jurisdiction. We don't know that, but that would be a subject of the UCCJEA conference that I need to have next week, hopefully.
Your Honor, could I please make one correction? My daughter.
Yes, Your Honor.
Casey, no.
Ma'am,
Hang on.
you do not at this point have that ability. You have an attorney.
Your Honor, maybe we can get rid of one of the easy motions that didn't have anything filed. I believe there's a motion to stay the discovery, and I believe there's a motion for my attorney fees. I think we can handle those today, and the UCCJEA can be the 12th if that's what's scheduled. But those are the two easy motions. I may be missing another motion here. And the restraining order is the only other thing that I would say. But I think those two at least are quite easy.
Would the court like me to respond?
Sure.
As far as a stay of discovery, I think that staying all proceedings are appropriate until the UCCJEA jurisdictional issue is determined. As far as the attorney's fee motion, I don't know if that's an ex parte motion that counsel is referencing, or if counsel is trying to squeeze in a CR11 motion, but I'd also ask that that be set over. Unless it's ex parte and it's attorney's fees between the court and counsel, that has nothing to do with me.
It is between the court and counsel. And you should have been served with those, but it's just for my fees for this case.
Yeah, I have nothing to offer on that issue.
I don't know that I've seen that motion, but unless I didn't. The only attorney's fee request I saw had to do with the CR11.
Oh, it was, we had a motion in order to shorten time, which was filed at the same time. And it was put onto this docket. It was signed by the court as well. I just assumed we'd be handling that. Yeah, it was, we had a motion in order to shorten time on, see if I can find the CP for your honor.
It looks like Judge Scudder may have signed something on the 25th.
Yes, that's it. Yes, it is at CP 43 is the order to shorten time. And then we have the motion for attorney fees are CP 42, and then my declaration at CP 45.
Well, I apologize, counsel, because that apparently got lost amongst the other 12 motions and responses that I was trying to address. I assume that was related to the CR11.
It is not related to that.
I've not had a chance to review that specifically.
If counsel has no objections, maybe your honor can review that and do an order ex parte. That's because I've been retained as court-appointed counsel under, I believe, GR 33.
As far as whether we have an objection or not, I don't think we actually have standing to object to court-appointed counsel's requests for fees. It's ex parte, and if I'm not mistaken, I think it doesn't concern us.
Yeah, I'll have to take a look at that in the normal course. I really don't have an ability to go through and look at that right this minute in docket. Those are normally done ex parte.
And I'll submit it ex parte.
And if I may indicate, Your Honor, as I mentioned, this case has been incredibly burdensome on my office. There are about 77 filings now with the court, the vast majority of those having been filed by petitioner's counsel. So I don't, there are many issues here that I simply cannot provide any responsive pleadings to, but if we can handle the UCCJEA issue and we could stay other proceedings in the meantime, once I withdraw, my client then may qualify for for the Northwest Justice Project to help her.
Well, let's talk about, I mean, just as a practical matter, and this is in the filing, that the memorandum that was filed, it looks like maybe yesterday. I don't know if you received that, which talks about this is what I mentioned earlier about essentially the answer indicated jurisdiction was fine here. That was done back in January. It should be back in December.
If I can briefly respond, Your Honor, this is my mistake in terms of my failure to seek leave from the court to go ahead and amend or answer. I had COVID. I came down with COVID around the 20th of December. I was extremely ill. I ended up in urgent care on the 31st of December with pneumonia, got antibiotics. I continued to be very ill and largely unable to work until somewhere around the 10th or the 12th of January, after which point we had an ice storm, which made it nearly impossible to get work done because of power failures and power outages in the Portland area, which prevented me from having access to my computer. I lost my family law attorney last fall. I'm in the process of hiring another one, but I'm trying to handle a full criminal caseload, oversee civil litigation and personal injury matters. And now I'm trying to handle family law matters in my office as well. And I'm a month behind. That is my fault, Your Honor. And also, I should have asked the court for leave to amend. I was overwhelmed by the number of filings in this case, and I'll have to file a motion to get the court's permission for a late amendment. And all I can say is my client left the state. We were incredibly open about that decision. I served counsel, in fact, with my ex parte motion to stay the order. I didn't have to serve her with those requests, but I was not served with her requests, and timely at all. I served her prior to filing my requests, did everything I could to inform her of the situation that my client felt she was unable to continue living in Washington because of circumstances, including her original intent to return in March and the cost of this litigation. I would just ask for leave to go ahead and file a motion to amend. As far as our original answer, my client made a decision. I should have filed a motion for leave to amend, but I was overwhelmed by my illness, and I apologize to the court.
Your Honor, if I might respond. The reason for the extensive pleadings was that we had no indication that Ms. Hawkins had fled the state until January 5th when we got an amended response. There was no emails. There was nothing else to say she had left the state minus that response. Immediately upon getting that response, we filed the restraining order ex parte. This is a massive problem. And the thing is the law and the case law are very clear. You get the 20 days. That's it. The time limit is much like when it comes to looking back at the time of the original pleading to look back, the time in that cannot be changed. The court can not extend or restrict that time. The 20 days is essentially set. And this, to now ask that it be amended February 6th, when it should have been amended before, is a massive problem. The fact is on February 5th, they filed the pleading with just a pleading. There was no motion. If they could file that pleading on January 5th, why didn't they file the motion to amend?
If I may
the fact is not proceed. The fact is it's not.
Oh. Counsel, stop a second. You can
Your Honor.
respond when she's done, counsel. Go ahead, Ms. Winkles.
Yeah, the fact is it's just not procedurally correct. You can't look back in time unless you follow the time rules. It puts that time rule there, that 20 days for a specific reason. And that specific reason is statutory. It does not change. It cannot change. And I can brief Your Honor on that if need be, but I know that Your Honor already knows that. The fact is the original response is the only good response in this case. There is no additional response. And at this point, you can see the prejudice that it would cause. All of the filings, we had very minimal filings at the beginning. All of the filings in this case have come as a result, if you look at it, have come as a result of Ms. Hawkins fleeing the state. The rest of it was just your standard motion. It was a standard motion for temporary orders, and that was it. And now we have all of this, the rest of this, as a response to Ms. Hawkins' actions. So when it comes to staying discovery, that makes sense. When it comes to staying everything else, that doesn't make sense because there is nothing. We have a protection order where Ms. Hawkins said she was resident here in the state. We have school records which show she's resident here in the state. We have her first agreeing and then waiting a month right before she leaves after we file these things to then leave the state and say, wait, I was never a resident there. That's not how it works. She was clearly living here for 6 months. It wasn't a temporary absence. She was clearly living here. And the court will know that notice that the law is not whether or not it's her subjective belief as to why she was here. It's the other parents. That's the case law under the UCCJA, which is in my memorandum. My client wouldn't have moved here if he thought that this was not the jurisdiction. And so I'd ask Your Honor, I mean, the fact is that we can set this, but procedurally, she's agreed to jurisdiction. There's no way out of that at this point. She should have done a motion to amend, and she didn't. So at this date and time, which is all the court's looking at, is this picture of what the case is as of this time, then jurisdictions in Washington. And I'd ask to go forward on everything. I didn't mind staying discovery, but I would ask that mom present the children here. There's still a good court order. And it doesn't appear that anybody is making any headway. Mom says she can't afford it. Now she shouldn't have left in the first place. There was a court order. There was the original. If we were still in the era at the time of COVID, it would be don't take the child out of the state. Those are my concerns, Your Honor, but I defer to your judgment.
May I respond?
Yes.
So, Your Honor, counsel did not bring this procedural response or the complaint about the amended response until I was given her response at like 3:35 p.m. yesterday. I'd asked to brief on the issue. I frankly have not researched the issue as to whether when I filed that amended pleading, I was extremely ill. I didn't have anyone who knows family law well enough to intervene on my behalf, and I realized that I needed to do that based on my client's decision to leave and return to her husband and her daughter in Texas, where they have lived for the last probably 11 years. And that was clear that petitioner could have easily known, and in fact did know based on his continuing campaign of harassment, of my client at her home in Texas and her children. That was going on long before anything was filed here. The daughter, Dylan, was being harassed and my client was being harassed on an ongoing basis. So, you know, petitioner easily could have filed in Texas. To use procedural tricks at this point, I just ask that I be allowed to respond to that allegation. I haven't researched the issue as far as my late amendment or my attempted late amendment without leave of the court. I was incredibly ill. As I mentioned, I knew I had a couple things to do and I tried, and I didn't have anybody in my stead to cover while I was recuperating. And then we had the ice storm, which made it impossible. So, you know, given those emergencies, all I can say is it's my fault, but it was certainly not intentional or careless on my part. It had to do with the fact that I had pneumonia and had low oxygen and could barely breathe. I would ask that the court simply give us the chance to fully brief this. If the court wants to have an evidentiary hearing, I don't know that we can do that today, but I certainly am not prepared to respond. And frankly, opposing counsel could have raised that allegation as far as our failure to timely amend. They could have raised that earlier in their initial UCCJEA petition. I could have responded adequately. They didn't bother to raise that issue until 3:35 yesterday. And I need to research it. Frankly, I've also been incredibly overwhelmed by their litigation, and I have asked repeatedly to hold off until we get the jurisdictional issue entered. It is not true that they filed barely anything prior to my client departing. There were many, many things, including a baseless sexual assault allegation. There were interrogatories served on us. There was a lot of litigation that was happening at the time my client became overwhelmed and decided to depart the state. Frankly, there were no pending orders. There was a filing, but there were no pending orders in this case. I did not see that it would be problematic for her to depart the state. And as I've indicated in one of my declarations, I indicated that to her. I believe that Texas is the home state, certainly for Dylan. King, I think there's a question as to jurisdiction, but forum nonconvenience, I don't believe. And I'd like to brief on the issue of that opposing counsel is raised, where opposing counsel is saying that forum nonconvenience is not even considered when you apply the UCCJEA's hierarchy. That's contrary to all my research, and I'd like to be given the chance to respond. And frankly, I don't want to. I'm so deep into this pro bono at this point that this has become abusive to me personally, but I'm also not willing to abandon my client at this point. I'd like to handle the jurisdictional issue for her.
Okay, so here's where I guess we're at this juncture. I think presumptively based on the response, which is essentially agreeing to jurisdiction here, that was filed December 6th. That's kind of where we're sitting right this minute. I don't have a problem since I frankly got, I don't know how many pages of stuff just came in yesterday, which I did not have a chance to review until this morning because I was in court all day yesterday. I don't have a problem in allowing a response, so legal briefing on that issue, because I mean the jurisdictional issue is the issue in this case at this juncture. Well, there's a number of issues, but that's obviously the primary one. The concern I have is I've got, at least at this juncture, it doesn't show on the court docket sheet, but I do believe there is a hearing set for the 12th for a UCCJEA conference, which obviously counsel you're entitled to sit in on, and that would be on the record. I'm not sure if we've got that scheduled time-wise yet, but we would obviously let you know when that was. So it would probably be helpful if I had that determined prior to sitting down with the Texas judge. And again, I mean, I think there's really two issues. One is you got two different kids, and it seems like from what I can kind of glean from all this is that there may be a different analysis between the kids. So, which, I've dealt with cases like that historically where we have two cases going with two different kids in two different states. It's unfortunate, but that may be a possible outcome as well. So I guess what I would be inclined to do would be to how much time would you need to get a brief back on those two issues specifically about the answer, as well as the forum nonconvenience?
Well, I have a law clerk to help maybe one additional day this week. If I could have until Friday, well, if I could actually have until, I was going to say Friday, 5 p.m., but if I could bleed over into the weekend and have it filed with the court by if I can provide it by email to the court by 10 a.m., before 10 a.m. on the 12th. I may be able to come up with something prior to that, but I have an incredibly full litigation calendar this week.
Ms. Winkles, I
sorry,
assume you're going
it's
to want to have a
litigation
chance to
appointments.
respond to that?
Pending clients.
Yes, Your Honor, I can get my response back in 24 hours
Okay,
or
so
less.
here's what I'm thinking then is I don't have a problem with you getting it by the 12th. That probably works well. I mean, I know I'm in trial the rest of the week on some other matters, so you can have that here. An email is fine on that. You will need to file a copy, but a bench copy by email is fine by the 12th. And let me give Ms. Winkles till the 14th. I think 24 hours is probably a little unreasonable given dockets and things. So the 14th by close of business. I'm probably going to push out the conference with a Texas judge so I can at least look at that, because I don't know that I could have an intelligent discussion with him until I look at those issues.
I will have my client provide the briefing in this matter, the briefing on the UCCJEA and jurisdictional issues and anything else that appears relevant. I'll have her make that available to the Texas court as well.
Fine.
If she can.
And speaking of that, can we get somewhere to be able to file ours as well? Normally in these cases, we just email the judge because we've had kind of a preliminary discussion, but is there an email address that we can send the judge our pleadings as well?
In California or in Texas?
In Texas, yeah.
I don't think I'm at liberty to give out the judge's email address.
Okay, can we email them
We
to
have
you?
provided full contact information to opposing counsel with all of everything that was filed down there, which does include the court's contact information and telephone numbers.
That'd probably be the best route. You may be fine getting it that way. I don't.
My concern is filing because it's a waiver of jurisdiction to respond. And so that's why I didn't want to file anything in the actual court. Usually we would just email them. That's what we did in that California case last year. And so I don't want to file anything in the Texas court. I just want to, for the judge, I want it made available for the judge in the UCCJEA only. I'm not sure how to go about that.
I think if you contact the court there and explain what the purpose of it is, I think that can, I don't think participating in a UCCJEA conference is a submission to jurisdiction, but if there's a concern about that, obviously we're trying to determine jurisdiction. The judge that we're working with at this point is Judge Matt Hand, H-A-N-D. And it looks like he's in Potter County.
And just to clarify for the record, Your Honor, we originally objected to jurisdiction as to Dillon, and we amended as to King.
Okay, and like I said, there may be a different discussion as to each of the children, which creates its own challenges.
Which I believe form nonconvenience then comes in. So we'll brief on that, Your Honor. Thank you.
All right, yeah, and Ms. Winkles, it looks like the I can't copy that. What I can do, there's a person, Tina Hoffman, who is the supervisor there. I can give you the phone number for that person.
That'd be great.
It's 806. That's in Amarillo, Texas. So for time purposes.
Okay.
That's the supervisor of the family law department, who's kind of the liaison that we're working through.
Perfect. Thank you, Your Honor.
All right. So at this point, then I guess what I'm going to do is I'm going to set this on for review in 2 weeks on the 20th. Just so we have a placeholder. I don't want to have to file, you guys have to file a bunch more documents to get it back on docket. I'll take a look at what you have, and I'm going to we'll reach out to the bench down there and see if we can push this out a week, maybe to the 19th for the UCCJEA conference, at least, depending on what I come up with once I see your briefing.
Okay.
And Your Honor, may I have permission? I am in a position of having a conflict with further litigation. Ms. Winkles indicates she intends to engage in further litigation in this case. We haven't had a ruling from the court staying matters. I will respond as far as the jurisdictional issues in this case, but Your Honor, I have a personal conflict I have a conflict of interest at this point as to further litigation. I've got so many hours in this, it's ruining my practice and it's affecting my family. I can't do this any longer for free. And I would like to enter immediate notice of withdrawal and then a limited notice of appearance just to cover the jurisdictional issues. I'd like to have leave of court to do that. My client is going to need assistance, but I cannot provide it as to any other issues in this case.
I think that's between you and your client. You're not appointed counsel, so I don't have any say whether you can stay in the case or not.
I'm not. Well, 10 days notice is normally required in terms of my filing of a notice of withdrawal. And I've got a conflict as to further litigation. So I'm just going to put that on the record at this point. And I don't want to have to walk away from the jurisdictional issue, but I cannot continue to provide free services. And that's
okay,
the position that the opposing counsel has placed me in.
That's between you and your client. If you want to file a limited notice of appearance, I don't know that Ms. Winkles has any particular, I don't know.
No dog in this fight.
I mean, that's between you and your client. I think there's a lot of other issues in this case outside of jurisdiction, depending on the outcome of that decision. So I would suggest if that's what your plan is, you and your client probably need to discuss what her future plans are for court, because assuming just that jurisdiction is determined to be in Washington, then she's going to need to deal with it here.
As I mentioned, she may be able to get assistance from the Northwest Justice Project, but they will not look at the case while she still has counsel. And I'm in an ethical dilemma, frankly, Your Honor, where
I don't need to know about it.
I have to figure it out.
Okay, so I'm going to put it on for review on the 20th at 1 o'clock. I'll look forward to your briefing, and if I can get a decision to you more quickly, I'll try and get you at least an email ruling next week so that we have that in place. And I may even push the UCCJE out with Texas a little bit farther just to so I can deal with it, our end of it first. Okay.
Thank you.
Thank you, Your Honor.
Okay. I believe that's everything we're going to handle on this case today.